With the Supreme Court's recent decision and the language on these papers right here, we are looking at the end of assault weapons bans.
Now, Democrats in the General Assembly also pushing ahead with one of their most controversial gun control measures, the ban on assault weapons.
So two major cases challenging rifle bans and magazine bans are in front of the Supreme Court. And these cases are currently not alone.
They start comparing civilian firearms to military. Like the military doesn't use pistols, knives, who civilians are already allowed to own.
A federal judge just overturned the ban in California on assault weapons that has been in place since 1989.
They take things millions of Americans own legally, relabel them as dangerous, and then they change the definition.
Right now, as you're watching this, the Supreme Court has multiple cases sitting on its desk that could determine whether millions of Americans get to keep their rifles and magazines or lose them forever. And what the court just did today, it's sending a signal that nobody expected. Here's what's unfolding. Two blockbuster cases challenging rifle bans and magazine bans are currently before the highest court in the land, but they're not sitting there alone. Several additional challenges from different states, different circuits, different plaintiffs have all converged at the exact same conference. And instead of making a decision, the Supreme Court just punted. Again, these cases have been relisted for yet another conference, and the number of times this has happened is now reaching a level that demands serious attention. So let's walk through exactly what's going on, what the relisting pattern actually tells us, and why the next few days could be one of the most consequential moments for the Second Amendment in years. Let's set the stage. For a long time now, the Supreme Court has been ducking one of the most fundamental questions in modern firearms law. It's a straightforward question, really. Does the Second Amendment protect commonly owned semi-automatic rifles like the AR-15, and does it protect standard capacity magazines? That's it. That's the core issue. And yet, despite years of litigation, despite conflicting rulings from federal courts all across the country, the Supreme Court has refused to give a definitive answer. Now, the reason this matters so much is that the lower courts are an absolute mess on this topic. Some federal circuits have ruled that these firearms are clearly protected under the Second Amendment because they are overwhelmingly owned by law-abiding citizens for lawful purposes. Other circuits have gone the opposite direction, arguing that these rifles are essentially military weapons, too dangerous for civilian hands, and therefore subject to outright prohibition. And then you have a third camp. Courts that acknowledge these firearms might technically be protected arms, but still conclude that governments can ban them anyway under various balancing tests. It's chaos, and it's exactly the kind of deep circuit split that the Supreme Court is supposed to resolve. So now, let's talk about the two anchor cases driving this entire situation. The first is a challenge to Cook County's ban on so-called assault weapons. This ban covers AR-15 platform rifles and dozens of other commonly owned semi-automatic firearms. The plaintiffs in this case are making a powerful argument. These rifles exist in the tens of millions across America. They are used overwhelmingly for lawful purposes like home defense and sport shooting, and under existing Supreme Court precedent from both the Heller decision and the Bruin decision, the government simply cannot ban an entire class of arms that are in common use. They're asking the court to draw that line clearly and permanently.
Taking on gun control with big reforms passed through committees on party line vote.
And one of those changes would ban assault weapons.
Some say that these are protected arms. Others say that they are too militaristic in nature, that they're too useful in military service.
What they've done now is they have modified their assault weapons ban so that it touches not just assault weapons, but magazines.
This is not some gun rights attorney saying it. This is the U.S. government admitting it. They're saying these laws don't survive Bruin.
It doesn't matter if it's a musket or something that's more modern. They both apply the same to the actual text of our Constitution.
For a decade, there was a ban on so-called assault weapons and high-capacity ammunition magazines.
The second major case involves California's magazine capacity ban. This one has a particularly interesting history because the Supreme Court actually touched it once before. After the Bruin decision came down, the court granted review, vacated the lower court's ruling, and sent the case back down to be reconsidered under Bruin's new framework. And what happened? The Ninth Circuit looked at it again and upheld the magazine ban anyway, so now the case is back at the Supreme Court's doorstep, essentially saying, we did what you told us to do, and the lower court ignored you. Fix this. Now here's where things get really interesting, and this is the part that has legal observers paying very close attention. These two cases didn't just show up at the Supreme Court independently. They arrived at the same conference alongside multiple other rifle ban and magazine ban challenges from different jurisdictions, We're talking about cases from different states, decided by different circuit courts, all raising the same fundamental constitutional question, and the Supreme Court is looking at all of them simultaneously. Why does that matter? Because historically, when the court wants to issue a sweeping, nationally binding ruling on a constitutional question, it helps to have multiple cases presenting the issue from different angles. Instead of taking one isolated challenge from one state, where opponents might argue there are procedural problems or that it's the wrong vehicle, the court can survey the entire landscape. It can see how different circuits reach different conclusions, identify the conflicts, and craft a ruling that addresses the issue comprehensively. This is exactly the kind of setup that several justices have hinted they were waiting for. But here's the tension. Despite this seemingly perfect alignment of cases, the Supreme Court keeps relisting them. Today's order list came out, and once again, none of these cases were granted review. None of them were denied either. They were simply pushed to the next conference, which is scheduled for this Friday. That means the magazine ban case has now been relisted 8 times, the rifle ban case has been relisted 7 times, and the other companion cases have accumulated their own growing list of relists as well. So what does relisting actually mean, and should we be worried or encouraged? This is where it gets complicated, and honestly, this is where the real drama is hiding. A relist means the justices didn't reach a final decision on whether to take the case. It gets pushed to the next private conference for further discussion. Now, statistically, cases that get relisted at least once do have a higher probability of eventually being granted review compared to cases that are denied outright on first consideration. That's a real pattern backed by data. But, and this is a significant but, cases that get relisted many times can go in either direction.
These rifles are in common use for lawful purposes and therefore protected under the Second Amendment and Supreme Court precedent like Heller and Bruin.
Cannot ban an entire class of firearms that are commonly chosen by law-abiding citizens.
2 guns can function the exact same way. One's legal, one's illegal, because of how it looks.
Stricter gun laws took another step to become reality, passing the Senate just a few days ago. The bill would prevent the sale of certain firearms.
So we are heading towards one of the most important Supreme Court moments for gun rights in many years.
Major Second Amendment case is before the Supreme Court today.
On the encouraging side, some of the biggest Second Amendment cases in recent history were relisted extensively before being granted. The Bruin case, which revolutionized Second Amendment law, was relisted roughly 10 or more times before the court finally agreed to hear it. The Cargill case involving bump stocks went through a similar cycle. So did other landmark cases. Heavy relisting doesn't automatically mean rejection. On the discouraging side, there's another pattern that's equally real. Sometimes a case gets relisted repeatedly because 1 or 2 justices want to write a dissent from the denial of review. They're not trying to get the case granted. They know they don't have 4 votes for that. Instead, they're drafting a written statement explaining why the court should have taken the case, putting their objections on the record. We saw this happen with other firearms cases in recent terms. The case gets relisted 5, 6, 7 times, and then one day it appears on the order list as denied, accompanied by a sharp dissent from a justice or 2 lamenting the court's refusal to act. So, which scenario are we looking at here? That's the million-dollar question, and truthfully, nobody outside the court knows for certain. But there are some clues worth considering. First, remember that when a previous rifle ban case was denied review not long ago, Justice Kavanaugh issued a notable statement. He didn't just let the denial pass silently. He specifically wrote that the court would need to address the constitutionality of rifle bans within a term or 2. That was a public commitment from a sitting justice, and it carried weight because Kavanaugh is widely considered a swing vote on these issues. Well, we're now in that window. If the court denies all of these cases without a word, it would effectively mean that promise meant nothing, and justices generally don't make public statements like that lightly. Second, the sheer volume of cases converging right now is unusual. Having this many challenges from this many circuits all hitting the same conference creates enormous pressure. The circuit split is undeniable. The conflict in legal reasoning is glaring. The number of Americans affected is massive. Every factor that typically motivates the Supreme Court to grant review is present here in abundance. But let's also be honest about the worst-case scenarios because they're real possibilities too. The court could be dragging this out simply to push it to the end of the term. There's a practice where the court holds what's called a cleanup conference at the end of each term, where they dispose of remaining petitions in bulk. If these cases keep getting relisted week after week until June, and then suddenly appear as denied on a final order list, that would be a devastating outcome. It would signal that despite all the rhetoric, despite the circuit split, despite the promises, the current court simply lacks the will or the votes to tackle this issue head on. There's also a middle ground possibility that's worth mentioning. The court might be waiting for a different case entirely, one that's still working its way through the lower courts, that the justices believe presents the issue more cleanly. If that's what's happening, the current cases might be held in a kind of limbo until that preferred vehicle arrives. It wouldn't be the first time the court has played that game. So where does all of this leave us right now today? We have the two primary cases, the Cook County Rifle Ban Challenge and the California Magazine Ban Challenge, along with their companion cases, all relisted for conference this Friday. Next week, when the court releases its next order list, we'll know whether these cases survived another round or whether the hammer finally dropped. The best outcome would be a grant of review on one or more of these cases, potentially consolidating the rifle and magazine questions into a single blockbuster term. A decent outcome would be a grant on even just one case, signaling the court is finally ready to engage. The worst outcome would be a flat denial across the board with no explanation, a silent refusal that leaves millions of gun owners in legal limbo and lets contradictory lower court rulings stand indefinitely. The stakes here cannot be overstated. A Supreme Court ruling affirming that commonly owned rifles and standard capacity magazines are constitutionally protected would invalidate bans in multiple states overnight. A refusal to act leaves those bans in place and arguably emboldens other jurisdictions to pass similar restrictions. Every week that passes without a decision is another week where the fundamental question of what the Second Amendment actually protects remains unanswered at the highest level. This Friday's conference could be the turning point, or it could be another delay in what's becoming an agonizingly long wait. Either way, the moment these cases appear on the next order list, we'll break down exactly what happened and what it means going forward. That's it for today, folks. See you in the next video.